Hello everyone, and welcome to our webinar on Brexit and the new immigration system. My name's Shabana Mania, and my colleagues Charlotte Smith, Suzanne Treen and I from the Walker Morris Business Immigration team will take you through this session. Hopefully you can see the slides on your screens, but if you can't, then please do send us a message using the Q&A function that's on the screen, and we'll try and sort that out if there's a problem. We're aiming to talk for around 45 minutes, and then we'll leave around 15 minutes at the end to take your questions. If you have any questions, again, please feel free to use the Q&A function on your screen, and we will try to go through as many questions as we can at the end of the session. Just moving on to the first slide then, looking at the agenda. The first thing we're going to look at is Brexit and the impact of the ending of freedom of movement on EU nationals. We'll then look at the new points-based immigration system in a bit of detail. We'll move on to look at business travel and other temporary routes outside of the points-based system that you might come across. And finally, we'll look at practical tips that you can be sharing with your business to prepare for the new system, including the risks of getting things wrong and preparing inadequately for the new system. So first of all, then, looking at Brexit and the end of freedom of movement for EU nationals. Brexit preparations have probably inevitably been on the back burner for lots of organisations this year, simply because we've all been dealing with COVID-19 and all the repercussions of that. So lots of businesses have been focusing on furloughing staff, getting staff back to work, generally just trying to stay afloat in these uncertain times. But in the background, the UK's march towards formally cutting ties with the EU have continued. And there are now only 3 weeks left till the end of the Brexit transition period, and therefore until the end of freedom of movement for EU nationals. And what this means is that from the 1st of January, what's being billed by the government as its new points-based immigration system will come into effect and will apply to both EU nationals and non-EU nationals alike. And we'll come on to consider the detail of what the new system will look like in shortly. But the key thing to stress at the outset is that for the first time, from the 1st of January, EU nationals coming to the UK for work purposes for the first time will be subject to the immigration system, which previously hasn't applied to them. And that's important because it signifies a total shift in the way that businesses can employ people from the EU from the 1st of January. It's worth noting at this stage that Irish nationals will continue to be exempt from immigration controls. So Irish nationals have the right to come and live and work in the UK, which is outside of their rights as EU nationals, and their rights will continue, and they will continue to enjoy freedom of movement even after the 1st of January. If we move on to the next slide then, I've set out there a quote from a government policy paper which was published in February of this year. And despite the government previously sending out the message that overall net migration would reduce as a result of Brexit, actually it's going to be easier to sponsor skilled workers under the new system than it currently is. And we'll go on to look in a bit more detail as to why that is. So it's widely anticipated that the number of skilled workers coming to the UK will actually increase under the new system. However, what the government has always been clear about, and what's reflected in this quote, is that there is no longer going to be a route of entry for low-skilled workers from the EU. And employers who rely on cheap labour from Europe, and that's their terminology, not mine, will need to adjust to the new regime and instead focus on technology and automation. So what is the impact of freedom of movement ending then? Well, why was free movement of European nationals so important in the first place to so many businesses and to recruitment? Freedom of movement of EU nationals effectively meant that UK employers could recruit nationals, either EU nationals who are already in the UK or EU nationals directly from their home EU country without any additional restrictions that already applied to UK workers. So there was no need for sponsorship, no visa to obtain, no additional fees to pay. All you needed to do was to see an EU passport or an EU national identity card, and you could recruit that individual on the basis of that document. It didn't matter what skills the EU national had, what level of pay they were going to receive, how skilled the role that they were going to fill in the UK was. all of that was irrelevant. They had the freedom to come and work here regardless of what job they were doing. The end of freedom of movement, therefore, means a number of practical things for your businesses. It means that for the first time, workers who you recruit from the EU will need to be sponsored, i.e. you will need to have a sponsor license before you can recruit individuals from the EU. So effectively, there's going to be a smaller pool of talent that you are now going to be able to recruit without having a sponsor license. It means that only skilled roles that meet certain minimum salary thresholds will be capable of sponsorship. So as we've already said, it previously didn't matter what kind of role the individual was coming to do, and lots of low-skilled roles have traditionally been filled by EU workers across a number of sectors. And it also means, and this is quite significant, but it means that for the first time, EU nationals coming to work in the UK will have to be able to demonstrate that they have sufficient English language skills and that they have sufficient funds to maintain themselves and any family members who they're bringing with them in order to be eligible for sponsorship. And ultimately, the net effect of all this is that it means that many of you who haven't necessarily had to engage with the UK's immigration system or the UK sponsorship system in the past, because your recruitment has focused on the UK and the EU labour market, will now find yourselves having to engage in this sponsorship process going forward. And those of you who already have a sponsor licence and have previously only used it to recruit for niche specialist roles might well find yourselves having to reach for that sponsor licence more frequently in the future when it comes to recruiting from the EU. And in reality, different sectors will face different challenges as a result of the freedom of movement of EU nationals coming to an end. We know that some sectors are more heavily reliant on EU workers than others, so construction, retail, hospitality, the social care, health and social care sectors are all heavily reliant on EU workers and are going to probably be disproportionately affected by these changes. The other point worth making is it may well also be that some sectors that have been significantly hit by COVID-related restrictions will initially not see a massive demand to recruit from outside the UK. So sectors like retail and hospitality that have potentially seen a dip in their recruitment needs in the short term may well find that in the longer term they are having to turn to sponsor licenses more heavily. But overall, the key message is that lots more employers will be registering as sponsors and sponsoring migrant workers. And the Home Office has already seen an uptick in the number of applications it has received, and that's likely to continue as we move into the new year. So if we move on to look at the EU settlement scheme then, we've already said that the new immigration system will apply to EU workers who come to work for the first time into the UK after the 1st of January or from the 1st of January onwards. But what about existing EU workers who are already in the UK? What steps do they need to take to maintain their current rights to live and work in the UK? I'm sure the majority of you now will be familiar with the EU settlement scheme. It's been widely publicised by the government. And the EU settlement scheme is effectively the mechanism by which EU nationals who are already in the UK as at 11 p.m. on the 31st of December can preserve their rights to continue living and working in the UK and to remain outside the sponsorship regime effectively. The latest Home Office statistics show that as of September of this year, more than 4 million applications had been received to the scheme. So effectively what that means is that the vast majority of EU nationals who need to make an application under the scheme have already made their application now. It's available to EU, EEA and Swiss nationals and their family members. All those who don't already have an indefinite right to enter or an indefinite leave to remain in the UK will be required to make an application. And we're not going to go into the details of how an application is made, simply because, as I've already said, the vast majority of your EU workers should by now hopefully have already made their applications. But as employers, the key thing for you to bear in mind is this deadline of the 30th of June 2021. All your EU workers will have had to have made an application by the end of June in order to continue with in order to continue and preserve their right to live and work in the UK. So the government is giving EU nationals this 6-month grace period effectively, where they can continue making an application after the Brexit transition period ends. well, what rights do EU nationals gain under the scheme? If they can demonstrate that they've been in the UK and had continuous residence for 5 years, then they will be granted what's known as settled status, which is effectively an indefinite right to continue living and working in the UK. If they have less than 5 years continuous residence, they will be granted what's known as pre-settled status, which is effectively a time-limited right to continue living and working for a further 5 years, after which they can then apply for settled status. And the rights they gain if they make a successful application are effectively the right to continue living and working and accessing the NHS and social security and education as they currently do. Many of your EU workers, as we've already said, will have already applied under the scheme by now, but the key thing is communicating with them and making sure that anybody who hasn't applied knows that you're available to assist them if they need assistance with their application. It may well be that if you have a high percentage of EU nationals working for you, you think about some kind of a publicity campaign as we get closer to the end of June, just to make sure that anybody who hasn't made an application does get their application in on time. But ultimately, the key thing to remember is it's the responsibility of the individual to make the application under the EU settlement scheme. There's no requirement on you as their employer to tell them of the need to make their application. There's no requirement on the individual to inform you as their employer that they have made the application or what the outcome of the application is. And there is no right on you as the employer to ask your existing workforce to prove to you that they have made an application. So it's more about raising awareness of the need to make an application, but not asking individuals to prove that they have done. Because if you start asking for proof of an application from existing workers, then that's likely to be discriminatory and fall foul of discrimination legislation. So if we move on to the next slide then, the changes that will come into effect for EU workers mean that clearly at some point the right to work checks that you do for EU workers will have to change. So just thinking about how is all of this going to impact your right to work checking processes then? It's still going to be necessary to perform right to work checks on all employees before they start working for you in the same way as you currently do. But the key thing to bear in mind is that European passports and ID cards will still be acceptable right to work documents up until the end of June 2021. It's only after the end of June 2021, so from the 1st of July onwards, that new EU recruits are going to have to prove to you either their immigration status under the new points-based system or their immigration status under the EU settlement scheme. Now, obviously, that's going to create practical difficulties for employers because it means that if you are recruiting new EU nationals between the 1st of January and the 30th of June, they will be able to satisfy you of their right to work by presenting a right to work, a EU passport or a national identity card, but you as their employer are not necessarily going to know what date they first came to the UK, and therefore whether they are eligible under the EU settlement scheme or whether they might actually need to be sponsored at some point in the future. Based on guidance from the Home Office at the moment, based on what we've seen so far, as long as you have done the right to work check properly and you've seen the passport or the ID card and you've kept a copy as you should do under right to work legislation, then you will have established a statutory excuse and you will avoid any civil penalty if it does later transpire that the individual doesn't have the longer term right to work. But the important thing is, if at any point you find out as the employer that the individual isn't eligible under the EU settlement scheme or that they are eligible but they've not made an application in time, then potentially that falls within the criminal offence of knowingly employing somebody who doesn't have the right to work. And that is obviously a much more serious issue. We are hoping, I mean, that's kind of a loophole in the current system as things stand. We are hoping that the Home Office will issue further guidance at some point in the new year on practical steps to deal with right to work issues during this 6-month grace period, because it does put employers in an uncertain position with regards to an EU national's longer term eligibility to continue working in the UK. I suppose what you should be mindful of, though, is that any kind of concerted policy to avoid recruiting EU nationals during this 6-month grace period to avoid this uncertainty is likely to be discriminatory, so should be avoided. The government has indicated that there won't be any need to do retrospective checks on existing EU workers, so you won't need to, and in fact, again, it will be discriminatory to start asking existing EU workers to prove their right to work. And we will hopefully see some more guidance from the Home Office early next year on what the right to work checks will look like from the 1st of July onwards. So moving on to the next slide then, and looking at the new points-based system. We've already said the new points-based system will apply to EU workers coming into the UK for the first time from the 1st of January. The key message from the government really has been that this new system will be a fairer system because it will apply equally to everybody from outside the UK and Ireland, regardless of what nationality they are, because it will be focused on their skills and not their nationality. I think the first point I want to make about the new system is that it's not really a brand new system at all, even though the government made a lot about this introduction of a new points-based immigration system. It's really just the existing system extended to EU nationals and with a few tweaks and amendments. We already have a points-based immigration system in the UK, and that's not going to change dramatically. We will go on to look at what the changes are shortly. One thing to bear in mind with the new system, just moving on to the next slide, is that as well as the additional bureaucracy that's now going to come with it, recruitment from the EU, recruiting from the EU is now all of a sudden going to become a lot more expensive, because we've set out on the slide there the costs that are associated with applying for a sponsor license, if you're a medium or large employer, and thereafter the costs of actually taking one individual through the sponsorship process. And as you can see, that all adds up to almost £8,500 worth of additional fees that your recruitment budgets are going to have to cater for when it comes to the recruitment of EU nationals, which you've not had to previously think about before. And then thinking about what impact is this going to have on current sponsor licenses then? If we move on to the next slide, some of you might be thinking, well, we already have a sponsor license under the existing system. What steps do we need to take? What action do we need to take now to convert that to the new system? You'll be pleased to know that the answer is you don't need to take any proactive measures. The Home Office has automatically converted existing Tier 2 and Tier 5 sponsor licenses onto the new system. Some of the terminology will change, and Suzanne will come on to look at that in a minute. But ultimately, the sponsor license itself, as long as it's an existing active license, will automatically transfer across to the new system. Any unused certificates of sponsorship will automatically carry across to the new system, and your expiry date for the sponsor license will also be maintained. So your license will still expire on the date it was due to expire under the current system. So I'll now hand you over to my colleague Suzanne, who's going to take a closer look at the skilled worker route under the new points-based system with you.
Thanks, Shabana. So I think if we move on to the next slide, please, Charlotte. So I think, as Shabana has nicely outlined here, it's clear that under the new system, it's not hugely different in terms of having points, etc. The key point is, of course, that anybody who wants to sponsor a non-settled worker outside of the UK and Ireland needs to have a sponsor licence. And it's quite interesting to see here the government's intention from a policy paper they published earlier this year, which basically said they want to create a high-wage, high-skill, high-productivity economy. So if we take a look at the next slide, we'll see whether or not they will have achieved that stated aim. So for those of you who know about the joys of being a sponsor, you'll know that at the moment the existing Tier 2 general route is being replaced by a new skilled worker route. And the new route reduces the salary threshold and skill level requirements to the jobs. So previously it had to be at what's called RQF level 6, i.e. degree level. It's now at RQF level 3, which basically means A-levels or a vocational equivalent. Now, the new guidance says that the worker doesn't have to have A-levels or equivalent, but the work that they do must be at that level. And crucially, the job must be listed in the tables to the appendix of the immigration rules. It's really important to point out for those of you who are in the health and social care sector as well, is that there's that employers can also sponsor eligible healthcare workers under the health and care visa, which is a special subcategory of the skilled worker route. what they have done is they've removed the cap on the numbers sponsored each year. So that widens who can come into the UK, how many people can come in, because previously there was a cap of 20,700. That's no longer there. And as you remember, that was for Tier 2 general applications. Probably some of you will be celebrating because they're also abolishing the resident labour market test. Now, as you know, if you've ever painstakingly done one, you had to advertise them in 2 different areas, 2 different mediums, and for a certain prescribed period, and they had to include prescribed information in them. We no longer have to do that because it was seen as a bit of a barrier to getting people in. And the purpose of it was to ensure that a settled worker would get the job every time over any migrant worker. Well, that has gone now, but I'll come on to talk about how they're changing it slightly to focus more on genuine roles. Another key change is that there's an expansion in the jobs capable of sponsorship. So as Shabana has said, this is a route for skills, for skilled workers. But interesting, what they have done is they've reduced the level of skill. And in doing so, that has expanded and made a much wider range of jobs available for sponsorship and capable of sponsorship. They've also reduced the minimum salary level for sponsorship, which essentially goes from around 30k and the job role that was previously advertised for the Tier 2 general to 25,600. And that again reflects the expansion in roles. But it's also key to note that there are certain prescribed salary thresholds against job roles, which may mean that you could actually have a lower threshold for work if you meet the appropriate points. Another interesting point is that there is the ability to trade points. So where there are jobs in shortage occupations, such as nurses, or where an individual has a PhD relevant to their role, including science, technology and engineering and mathematics, those points can be traded off against these salary levels. And Charlotte will come on to talk about the other routes, including ICT, but it's key to note that they have removed the cooling off period for the ICT route, so that gives you a bit more flexibility. Could you put the next slide up, please? So the new skilled worker route is probably the key thing for us to look at today, and I'll just talk you through the tradable points and what this all actually means. So as I've said, it replaces the Tier 2 general route from the 1st of December, and it allows you to recruit people to work in the UK in a specific job in an eligible skilled occupation. Now, this applies to European Economic Area nationals who arrive in the UK after 11 p.m. on the 31st of December 2020, and non-EEA nationals, so everybody else in the world, who apply on or after the 1st of December. So if you have a role that you want somebody from outside of Europe to do, you can apply under the skilled worker route from now. Now, if successful, the applicant can be granted permission to stay for a period of employment up to 5 years. And the question really is, well, how do the points work? And if you read the guidance, you might need a big cup of tea and a wet flannel. But ultimately, it's logical and there are examples and you can work through them. And obviously, we're here to help you too. But the magic number is 70. So it's really simpler to think of the points as requirements. So the requirements are a job offer from an approved sponsor, so the company that holds the license, that gets you 20 points. The job must be at the appropriate skill level as set out in the occupational codes, and that's 20 points. And the individual must meet the English language requirements. So they've got to speak English at an intermediate level, and that's 10 points. And then the fourth requirement is that the salary level meets that which we've just talked about, which is the 25,600. Or the going rate for the role, whichever is higher. But this is the element which is tradable. So let's have a look at how this works. So we've set out a table here for you. So you can see the top 3 lines, that has the 20 points for each of those 2 elements. And then they're speaking English. That gets you your 50. But it's the salary element that's tradable. So if the skilled worker will earn less than the required minimum salary threshold, but no less than 20,480, they may still be able to come if they can demonstrate that they have a job on the shortage occupation list. So, for example, if you're a nurse, or a PhD in the subject which is relevant to the job, or one in a STEM qualification, and there are a couple of other factors there as well. So if you're a new entrant or if you're listed on a health or education occupation, and you can see the points there that can be tradable. Now, it's key to note that the salary must equal or exceed both 20,480 and a certain percentage of the going rate for the relevant occupation, and there are grades of these, and it's all set out in the appendix. So the specific percentage depends on which of the tradable criteria you're relying on. So let's, if I may, take you through an example. So let's say, for example, we've got Tom. He's an American citizen. He's got a job offer from Pfizer because he's going to help with the vaccine. Pfizer is a sponsor license holder, and his role is an important one. It's a development chemist, and he's been offered this job at a salary of 22,000. So would Tom meet the 70 points required? Well, as we've said, he's got a job offer from Pfizer. They're a sponsor, and they've obviously been in the news a lot lately, so he gets his 20 points tick. The development chemist is a role at the requisite level, so he'd get his 20 points there. He's an American citizen, so points are currently awarded for English language. If you're a national of a majority English-speaking country, he'd get 10 points there. So he's met all of the mandatory requirements. He gets his 50 points. The next is his salary, and is it between 2480 and 23039? It's not quite making the point now against his actual job occupation. So what we have to look at is that, does he have points elsewhere? So would he be on a shortage occupation list? Well, this role isn't, unless it's in Scotland and for the nuclear industry. So it doesn't fall into that category. He doesn't get the points there. But he can enter if he's got a PhD in a STEM subject, which is relevant to the job, and the salary exceeds 80% of the going rate for the occupational code. So the remaining points can be gained if this is the case. So he holds a PhD in chemistry. It would be relevant to the job. The going rate for this occupation is 26,700, and 80% of that is 21,360. So the 22,000 meets the requirements. He gets a big tick and he can come in. Now, I'm conscious that that is quite complicated because there are percentages and job skills. I think the key thing to do is to look at the appendices really carefully and look at the roles and where they end up. And obviously, if in doubt, speak to us, because where you're creating these roles, you want to make sure you're getting the right people and you're pitching it at the right level in order to pass the scrutiny of the Home Office. So I think let's go on to the next slide, we can have a look at the specific roles that we will be able to sponsor. So as I've said, that there is an expansion of the SOC, so that's the job, the occupational codes available, so the job types eligible for sponsorship. So curiously, having wanted to reduce the number of people coming into the country, actually what we appear to be doing is expanding it and making the skill level lower. There are obviously reasons for that, because the economy still needs a lot of people to come in and do those jobs. And that's why it's been reduced to RQF level 3. But obviously, there are problems, as Shabana has outlined, for businesses and industries that have a reliance on lower skilled labour, because there are many low paid jobs that require high level of skill but wouldn't be covered by the new system. So unfortunately, what it means is the new points-based system isn't going to give you the same level of access to the same range of workers as it has under free movement. But what it does do is it does give you a wider access to a wider range of roles. So for example, in the construction industry, builders, carpenters, welders, plumbers and electricians, in retail, leisure sector, sales supervisors, sale administrators, warehouse and logistic managers, food and drink industry, you've got chefs, butchers, bakers, bar, restaurant managers, and the health and social care sector, senior care assistants and nursing assistants. There's also a wide range of technical roles that would be covered, so lab technicians, IT technicians, pharmaceuticals, etc. But I think this won't help for many key roles, for example, in the food chain, production, manufacturing, as Shabana has outlined, that do rely heavily on these roles. For example, if you work in the social and healthcare, care workers and home carers, hospital porters, sales, retail assistant, all of these lower roles are not going to be covered, and you're going to have to look at ways of plugging those gaps, which Charlotte will come on to talk about. Now, the government has said that it will keep the labour market data under scrutiny to monitor any pressures in key sectors, but ultimately they're leaving it up to you to plug the shortage gap if you can at this stage. So in terms of the practical changes, well, as I've just talked about, there are obviously changes. So Tier 2 becomes skilled worker, ICT goes from Tier 2 ICT to intra-company transfer route, and they're described as the worker route. So it's not that difficult to get your head around those changes. Now, in terms of the genuine vacancy piece, although they have gotten rid of the resident labour market test, they are saying that there's a definition of genuine vacancy and it's been updated, and it's effectively saying you have to have the job holder performing the specific duties. It can't include dissimilar or predominantly lower skilled duties, and it has to be appropriate for the business model. And when you assign a certificate of sponsorship to a worker, what you're doing as a sponsor is guaranteeing that the role is genuine. So you have to be really clear that this is it. You can't up a role from a lower skilled role if the majority of the work involved in that role would be lower skilled. That is going to fall foul of the rules. And they've been very clear that they would refuse a worker's visa application and possibly take action against a sponsor if they're trying to effectively fiddle the role and it's not a genuine role. So I think real work needs to be done around ensuring that you've got the right role at the right skill level at the right salary. Now, as many of you will be aware, under the old system, there were two types of certificate of sponsorship. So they were called restricted and unrestricted. And as I've said, there was an annual cap on the number of restricted. Under the new system, the cap's been suspended, and restricted and unrestricted are called defined and undefined, respectively. I'm not sure how helpful or unhelpful that is, but there we are. So you must apply for a defined certificate of sponsorship if the worker you wish to sponsor will be making their application from outside the UK, and all other applications will require an undefined certificate. Now, you can request an annual allocation of undefined certificates of sponsorship and should assign them from their annual allocation, and you can ask for more if you don't have enough left. Assigning the wrong type of certificate may result in your sponsor licence being revoked, so again, care needs to be taken there. Another key piece here is really about the fact that the job codes no longer have example job tasks. So you will know, if you've been through the joys of this process, that you examine the job role, you look at the examples of the sort of tasks that they do and think, right, okay, we fall into that, that's fine. Well, they're no longer there as far as we can see. These are conspicuously absent, in fact, and they can still be found via the Office for National Statistics. So from one example, it might be easy to argue that jobs fit into a particular category, or it might mean that the Home Office take a much more prescriptive approach. Now, although they've already done it to a certain degree, I think what they're going to be doing is they're going to be routinely checking it and other job codes to make sure the job code that you have chosen falls into the right category. So I think the key point for you here is to make sure that you're not putting a lower skilled role into a higher skilled role, because you will be caught short by that. Hallelujah as well, documents can be loaded electronically, and this has been a sort of COVID issue when you're applying for a sponsor licence, and they're looking to continue that. They may still ask for originals or certified copies, etc. And as I've said, there's no longer the monthly allocation of the certificate of sponsorship, so you can carry out straightforward working applications in one working day, which is going to massively reduce the time it takes to sponsor somebody. And I think the impact of the changes really are quite obvious, which is it's going to be more difficult to recruit EU nationals than it currently is, but there's less of a barrier on the recruitment of those non-EU nationals compared to the previous system. Now, I think for those of you who have a sponsor licence, we've put this slide in here just so you can refresh your memory in terms of what your duties are. The duties are and remain the same, possibly more stringently, and I think it's fair to say the Home Office is going to be quite hot on following up on this. The other side of the coin, I suppose, is it is a very busy time for the government at the moment. So if you've made a mistake, if you've done something wrong, now is the time to possibly write in and own up and provide a solution, and you may get absolution on that basis. And again, we can help you with that. So overall, do we think it's a better system? Well, it's going to be expensive, as Shabana has outlined. You're not going to have the same access to the same pool of work, so you need to be more organised. It may take 8 weeks to apply for a licence, and we can expect delays. I think we were up to, my colleagues may correct me, but about 39,000 at the beginning of this month of sponsors. So that it's going up very quickly. And the key point is there's no skilled route. So I'll hand you over to Charlotte, who's going to give you all the answers. answers.
Thanks, Suzanne. So yeah, I think the route that Suzanne's talked about, the skilled worker route, is the one that you need to be most aware of because it's likely to be most relevant for employers. But there are lots of other different types of immigration routes, and it's just worth letting you know what else there is in terms of business immigration routes. So we'll touch on some of those. I'll also look at what the position is with regard to business travel. So what if European nationals want to come to the UK on a business trip? Can that still be done? Is a visa required? And vice versa, what is the position if us as UK nationals need to go and travel on business into the European Union? So the first other immigration route to mention is the intra-company transfer route. And this is a route that requires sponsorship. So this also requires the sponsor licence, which Suzanne talked about. If you're already a sponsor, you may be familiar with this route, but it essentially is for employees who are established in an overseas company, and if you are part of the same corporate group as that company, that employee can essentially be seconded to the UK company for a period of time. They have to have worked with the overseas company for a minimum period of 12 months before they can be seconded to the UK, unless they are a higher earner in the 73,900 bracket. And one important point to note about this route is that the skill level has not been reduced. So it's not the same as the skilled worker route, which has now been reduced to that RQF level 3. This is still at the higher RQF level 6 level. And it's also got a higher salary level of 41,500 for the minimum salary requirement to engage someone in this way. So there was a lot of talk about why we actually still need this intra-company transfer route, because in most cases, people are probably going to be eligible under the new skilled worker route now that that process has been simplified and now that the job levels have been brought down slightly on the new skilled worker route. I think the only sort of key difference really is that there isn't an English language requirement for intra-company transfers. So that may be one of the reasons that this has been kept. And you may still want to use this route if you're familiar with it and you do have a lot of international secondees. So an example might be if you're sort of part of a manufacturing business and there's an overseas company in Germany that's maybe more advanced than your manufacturing business in the UK. You've therefore got a project that you want to bring an engineer over to complete, so maybe creating a new piece of smart machinery or kit, and you think that that project will take 2 years to complete. It might therefore be that you can ask the German entity to second somebody to the UK entity for that period of 2 years if they meet the requisite level, so salary level, a skilled enough role, so skilled engineers, and they won't need the English language requirement in order to do that. It's important to note that this is still really a temporary route and there is no settlement route using just the intra-company transfer route. But as Suzanne said, there have been some other changes in that there isn't a cooling off period. So previously, if you were sponsored under an intra-company transfer licence, you would have to return to your home country. There's a cooling off period before you could apply again under any tier 2 route. That now doesn't apply, and instead you can switch to the general skilled worker route. So that might be good news for any current intra-company transfer employees that you have. The other routes that are worth a mention, and we won't go into them into detail because there isn't enough time on this webinar, but it's just worth being aware of these. These are all routes that don't require a sponsor licence, so you as an employer don't need to have a sponsor licence if you're employing people who have these sorts of visas. And it's really the eligibility of the individual that's important for these. So the first one is a representative of an overseas business. This only really applies if you've got an established business overseas and you want to set up a UK branch of that business. So there isn't already a presence here. You can send over a sole representative to set that up, and they must be quite a senior person who does that, who has authority to enter into contracts on behalf of that business. The next one to be aware of is this new graduate visa. This isn't actually in effect yet, but the government has promised that it should come into effect by this summer coming, so summer 2021, to enable international students who are already in the UK to use this graduate visa once they have completed their studies. And what that will allow graduates to do is it will allow them to stay in the UK for a period of 2 years after their studies, or 3 years if they've got a PhD, to look for work or to start work. And there isn't any minimum skill level of the work that they can do in that 2-year period. But obviously, if they then want to stay on a longer term basis, they would need to make sure that they're meeting the skills requirements of the general worker visa, which Suzanne talked about, and then switch into that visa after the graduate visa. So that's one to just watch out for. You might be able to employ graduates in lower skilled roles, but obviously the ultimate aim is that they eventually take those skilled roles after at least 2 years. It's also worth noting that students who are already in the UK are sponsored by their universities under a different tier, so tier 4, but they can also complete work as well while they're studying, but it's usually limited to 20 hours of work a week. But so you might have students who you employ, and again, there isn't a specific skills requirement for the roles that they do, but just be careful about the amount of hours that they do work for you. The Global Talent Visa is sort of quite a niche category for really the most highly skilled individuals in particular fields such as science, engineering, technology. And for that, you need to have an endorsement from a relevant governing body. And there doesn't have to be a job offer with that. You just have to have this endorsement. So it's really the government's message of having the best and the brightest people being able to immigrate to the UK. That's what these types of routes are trying to achieve. Similarly with the startup and innovator visas, those are really for entrepreneurs who are setting up new businesses in the UK. And again, you need to have an endorsement from a relevant body that says that that startup business is viable and scalable. The other one to mention is this new route of British nationals overseas, and this is relevant to Hong Kong nationals. And just to confuse matters even more, this won't come into effect on the 1st of January, but it will come into effect on the 31st of January. So some Hong Kong nationals will have a special British national overseas status where they already hold a British passport, but that doesn't mean that they are exempt from immigration control. They don't have the same right to just come and live and work in the UK as somebody who holds a normal British passport. But that is changing from the 31st of January so that people who hold this status can come to the UK and they don't need to be sponsored. They can get this special visa and they can come from the 31st of January. They don't have to have a job offer. So that's just another one to be aware of because there are about 3 million people, we think, who hold that status. So it could be one that is used in the future. Frontier workers is just a final one that I wanted to mention because I think people are often confused about what this is and what this means. And this is actually a route that has opened today on the 10th of December. And it essentially means that it's an individual who already has a job in the UK with a UK company, but they don't actually live in the UK. So there might not be that many people who this applies to, but if, for example, you have an EU national who lives in France but works for your UK company, then they are classed as a frontier worker, provided that they are actually working for the UK company. But they may work remotely most of the time, but just come over to the UK for business meetings, for example. If you are a frontier worker, you can continue to do that, provided that you secure your frontier worker status under this new system which is opening. But what you cannot do is you can't employ people in this way after the end of the transition period. They have to already have this status prior to the end of the transition period. It's not a new route that can be opened up after that. If you wanted to employ someone in that way in the future, then they would have to use the points-based system and the sponsor system, which Suzanne talked about instead. So that's some of the other routes that are available. So what about business visitors then and business travel? So in the first instance, we're looking at EU nationals who are travelling to the UK for business trips. And the key thing to note here is that you can't use this as a route to have really frequent trips in and out of the UK where actually you're working, because that would circumvent the points-based system. What you can do is have specific trips into the UK for specific purposes, which we will look at. And there isn't actually a general business visitor visa. It's just called the visitor visa, which is a general visa. And there's two different sets of people, and it applies slightly differently depending on which country you are a national of. So there are countries which are listed as visa nationals, and those are countries that include sort of China, the UAE, Turkey, South Africa. This means you have to apply for this visa before you actually arrive in the UK, so you've got to apply before you arrive at the airport. Non-visa nationals don't need to apply for it in advance, and that includes countries like the US, Australia, New Zealand. And from the 1st of January, European nationals will be classed as non-visa nationals. So the key thing is that you're a genuine visitor, and you should be able to show that you intend to leave the country at the end of your visit. You can stay for up to 6 months, but there has to be that intention to leave. And they will be able to ask at the border what the purpose of your trip is and ask for further information and evidence of that. So what are permitted activities? So there's general business activities which include sort of attending meetings and conferences. You can also come to close a deal and sign a contract. So in a similar way that Boris is over in the EU trying to conclude the trade deal, those sorts of things will be able to be done from the 1st of January, provided that it's not classed as working. There's also intra-corporate activities that can be done, and you can share skills and provide training, provided that that is with employees of the same corporate group. Installation of maintenance and equipment is also a really useful one, because if you are a UK company who has bought a piece of machinery or equipment from an overseas company, so for example in France, and something goes wrong with that piece of equipment, they might be able to send over an individual to fix it under the business visitor rule, so they won't need a specific visa to do that. Similarly, if you've got lorry drivers who are delivering goods into the UK from the EU, that is okay, and you can continue to come into the UK for that permitted activity without a visa. So what is the position in relation to UK workers who are travelling to the EU? Well, it's quite similar from what we know so far in terms of what you can and can't do. So the general position is that it's visa-free travel, but the timescales are slightly different. So you can only actually travel into an EU country for up to 90 days in any 180-day period. And actually that applies to the Schengen area as a whole. So to confuse things even more, the Schengen area is slightly different from the EU. So it includes most of the EU countries, but also includes other countries such as Iceland, Norway, Switzerland and Liechtenstein, who are not part of the European Union. So if you're travelling to any of that area, you can't stay for more than 3 months, essentially, in a 6-month period. And I think it's really important to note that if you have people who regularly travel around Europe, because it's cumulative throughout the different countries. It's not that you can spend 90 days in France and then 90 days in Germany. It's the total number of days in the Schengen area. So be really careful of that, because that could add up really quickly. And if you are going to go over that, then really you need to be looking at what visas apply for the specific country and whether you need a work visa for that country. And each of the countries will have their own specific requirements on that. So while the general business activities are similar as far as we are aware to the UK ones, you should always check the specific entry requirements for each individual European state. The other practical points to note as well, if you've got people who travel on business a lot, is that their passport should have at least 6 months on them until they expire. Medical insurance needs to be checked because the European health card isn't longer and valid any longer, so you need to have that insurance in place. And there might be some specific requirements in terms of driving, so some countries will require an international driver's permit if you are going to go into the UK to do that. So there's a lot of information there, a lot of different immigration routes and a lot of different things to consider. So very quickly, because we haven't got a lot of time left actually, I'll just talk you through some of the key practical steps that you can take. So the first question is obviously the sponsor license question, which we've already talked about. Do you have a sponsor license? If not, consider getting one. If you do, is it all in order? Have you got an authorising officer who has access to the system? Have you complied with your duties historically, which is the slide that Suzanne showed? There's lots of reporting requirements. If you haven't, then now is the time to sort of own up to that and make sure that you do comply going forward so that you can use this system in the future. Future workforce planning. So the first point, you've actually only got 3 weeks left to do this, but if you do have any EU nationals who you want to recruit now, then get them to come to the UK prior to the end of the transition period, because they are still eligible to apply for pre-settled status if they do that. The communication piece, I think Shabana already touched on, so make sure that EU workers are aware of the settled status scheme. They probably have already applied, but it might be worth just reinforcing what the requirements are. Factor in those costs. So again, we talked about the potential £8,500 cost of sponsoring someone from January next year. That's going to need to be factored into sort of your HR budget. And think about whether there's any skills gaps in the workforce that you might need to plug, and how do you do that? So again, the whole message from the government is we shouldn't be relying on cheap labour from Europe or from anywhere else. Instead, the concentration needs to be on investing in technology and in automation. So that is something to consider. And in order to do that, you're going to need the people who have the skills for that role. So apprenticeships are a really good place to start training, reskilling the workforce. And the other key point is obviously try and minimise staff turnover. If you've already got a really good workforce, then make sure people are incentivised to stay, because then you'll have less recruitment needs. The right to work policies point is to just watch out for what the new guidance says. So we are waiting for that to be published, hopefully in the new year. Make sure that once it is published, we're complying with the new guidance and staff are trained on how to do it. And all of this, the reason why it's key is that there are consequences if things go wrong. So if you don't complete right to work checks correctly, there can be civil and criminal penalties. That then has a knock-on effect if you want to sponsor people under the sponsor license system. You can have your license revoked if you already have one, or you will have difficulty applying for one if you don't. And that means that you could lose out on talented people. And there's the obvious point of reputational damage as well. So that's really all that we had to say. I know there isn't an awful lot of time left, but Shabana, if there's any couple of quick questions we could go through, then we can do that. If not, we can send you responses to any questions that come in now, and I'll make a note of them.
Thanks, Charlotte. There are a couple of questions we should be able to get through in the 5 minutes we've got left. The first one, I think this is probably for you, Suzanne. The timescales for processing sponsor licenses seem very long. Is there a fast track option available, and what about with visa applications?
So the answer is that I think it was in November the Home Office launched a priority service. So if you're using the standard application process, they say a standard timescale of 8 weeks, but they say applications are processed in sort of half that time. But you can pay £500 for the priority service, and that seeks to provide an outcome within 10 working days, although it might not be possible for all of them, because obviously quite a lot of people are applying for sponsor licenses at the moment. So it would probably be quicker and worth it if you had a particular role that you were trying to apply for and get your sponsor license. So if you need to apply for a visa, there are priority and super priority services, and I think they allow for a decision within 5 days, or I think super priority is 24 hours. And I think the employee's got to attend the biometric evidence take and provide supporting evidence, and I think they're about £1,000, depending on the type of services. So yes, in answer to the question, there are priority and fast track services available. You just have to pay more money for them.
Okay, thanks, Suzanne. The next question I think we'll answer is, will anything change about this system if there is a deal? E.g., could free movement of EU nationals form part of the deal? And that's obviously very topical given what we know about what's happening at the moment with the trade negotiations. Unfortunately, or fortunately, depending on your particular point of view, the immigration bill, which actually set out the legal framework for all of these changes, and that included the ending of freedom of movement for EEA nationals after the 31st of December, that immigration bill has already been passed. It's already been enacted into law in November of this year. So there isn't any immediate prospect of any of this changing, no matter what the outcome of the trade negotiations, whether there is a deal or no deal, as is looking increasingly likely. The other thing I suppose to bear in mind is that the whole immigration debate and the ending of freedom of movement was actually a central part of the whole Brexit debate. So any concessions regarding free movement of people now would be very unlikely and are not expected to happen. I think we've probably got time for one last question before we call it a day. And that is, what happens if our parent company in Europe simply wants to second someone on a temporary basis to the UK? What process do I have to use for that? And Charlotte, I think that's probably one for you to answer.
Yeah, so I mean, it depends really on what exactly you want them to do. If it's a true secondment in that they will be coming to the UK company to work, then you need to look at the points-based system. You could potentially use that intra-company transfer route, but actually they may well be eligible under the general route as well. However, if the intention is that they do go back to their employer in, Germany or wherever at the end of this, then the ICT route might be more applicable to you. So yeah, you should be using the points-based system if it's work. If it's just a business activity that we talked about for a temporary period, negotiating a contract or coming for a conference or something, then that's different and you could fall within the visitor rules for that.
Brilliant. Thank you, Charlotte. I think we'll have to call it a day there. We're very close to 1 o'clock. Thank you everyone for attending. If there are any questions that we haven't answered, we'll try to come back to you all individually with answers to your questions. Similarly, if there's anything you haven't thought of during this session, but you do want to ask us, then feel free to contact us using the contact details that are on your screen now. There's also some further information available on the Business Immigration Hub, and the link to that hub is also on the screen. So if there's anything you want to just check out, have a look on the Business Immigration Hub. We will circulate the slides that you've been seeing during this session. So those will be sent to you by email. And similarly, a recording of this webinar will also be available if you think it might be interesting to anybody else you work with, or if there's anything you just want to go back and have another look at. And as ever, we will be publishing further updates and guidance as further information becomes available from the Home Office. So if you're not already signed up to receive our updates, if you go to our website, you'll be able to sign up for our updates there. And I think all that's left to say is thank you all very much once again for attending. We hope you found it informative, and any queries at all, do feel free to get in touch with one of us.
Thank you.